Hi, my name is Valerie Robison. I'm a district court judge in the 21st Judicial District, Mesa County.
And I'm Carlos Zamor, a district court judge in the 18th Judicial District.
In this chapter, we're going to be discussing sentencing hearings. At the end, we will have contact information. Please feel free to contact us if you have any questions.
Sentencing might well be the most important and impactful part of our job as judges. Additionally, it can be the most public part of our job and the part of our job that can be most prone to criticism, including by the media.
The first things to consider are the purposes set out in the criminal code regarding sentencing. The purposes are to punish a convicted offender by assuring that the sentence is deserved in relation to the seriousness of the offense, to assure the fair and consistent treatment of all convicted, to prevent crime and promote respect for the law, to promote rehabilitation, to select a sentence length, and level of supervision that addresses the offender's individual characteristics and reduces the potential that the offender will engage in criminal conduct after completing his or her sentence, and to promote acceptance of responsibility and accountability by offenders, and to provide restoration and healing for victims and the community while attempting to reduce recidivism and the costs to society by the use of restorative justice practices. CRS 18.1.3401 provides the sentencing ranges for felonies, and CRS 18.1.3501 provides the sentencing ranges for misdemeanors. Trial courts are to balance the goals of protecting the rights of society and the rights of the defendant. We are instructed to consider the prior history and circumstances of the defendant and the facts surrounding the offense in determining whether there are facts which justify imposing a greater or lesser sentence than the presumptive range. If, in your discretion, you deviate from the presumptive range, either greater or lower, specific findings must be made on the record detailing the specific extraordinary circumstances which constitute the reasons for varying from the presumptive range. Make sure that this is a finding that you can make and does not need to be presented to the jury. If you are sentencing for a per se crime of violence or pursuant to the crime of violence statute, no findings are necessary, and you must sentence the defendant to a term of at least the midpoint in the presumptive range, but not more than twice the maximum term in the presumptive range. If you are sentencing to the Department of Corrections for a felony DUI, DUI per se, or DWAI, you must determine that incarceration is the most suitable option given the facts and circumstances of the case, including the defendant's willingness to participate in treatment. The court must consider whether all other reasonable and appropriate sanctions and responses to the violation that are available to the court have been exhausted, do not appear likely to be successful if tried, or present an unacceptable risk to public safety. Some improper aggravating sentencing considerations are the expense to the judicial system, the state of Colorado, or the taxpayers, and that the defendant was the sole individual involved in the crime. When deciding what sentence to impose, consider your desired outcome. Is it punishment? Is it rehabilitation? Is it public safety? Is it structure, or is it a combination of one or more? If considering restorative justice, the defendant must be eligible. To be eligible, the defendant shall not have been convicted of an unlawful sexual behavior, a crime involving domestic violence, stalking, or a violation of a protection order. For nonviolent offenders, there are specific factors that must be considered. The court is required to consider prior convictions, which includes a conviction by a jury or by a court, a deferred judgment and sentence, a deferred adjudication, and a plea of guilty or nolo contendere. The trial court may grant probation unless, having regard to the nature and circumstances of the offense and to the history and character of the defendant, it is satisfied that imprisonment is more appropriate because there is an undue risk during probation that the defendant will commit another crime. The defendant is in need of correctional treatment and imprisonment is needed. A sentence to probation will unduly depreciate the seriousness of the crime or undermine respect for the law. The past criminal record indicates probation would fail to accomplish the intended purposes, or the crime or the defendant's history and character, when considered in relation to statewide sentencing practices relating to persons in substantially similar circumstances, do not justify granting probation. Now, Carlos will talk to you about other aspects of sentencing.
Before you conduct a sentencing hearing, you must be aware of the Victims' Rights Act. Because we have an entire Bench Basics chapter on the Victims' Rights Act, I'm only going to highlight a few points here. First, Each victim of a crime has the right to be treated with fairness, respect, and dignity, and to be free from intimidation, harassment, or abuse throughout the criminal justice process. Second, each victim of a crime has the right to be informed and present for all critical stages of the criminal justice process, including a sentencing hearing. Third, each victim of a crime has the right to be heard at any court proceeding at which a person accused or convicted of a crime against the victim is sentenced. Finally, judicial agencies are among the agencies charged with ensuring that victims of crimes are afforded the rights described in the Victims' Rights Act. Let me talk about media-related issues next. What do you do if you get a motion for expanded media coverage of a sentencing hearing? Well, a good starting point is Rule 3 in Chapter 38. Just a few highlights about Rule 3. First, make sure that any request for expanded media coverage complies with the procedures that are set forth in the rule. Second, you must rule on any request for expanded media coverage on the record, and you must provide the reasons for your ruling. In other words, simply stating granted or denied won't suffice. Third, Rule 3 outlines the standards governing requests for expanded media coverage. The court must consider 3 factors. 1, whether there is a reasonable likelihood that expanded media coverage would interfere with the rights of the parties to a fair trial. 2, whether there is a reasonable likelihood that expanded media coverage would unduly detract from the solemnity, decorum, and dignity of the court. And 3, whether expanded media coverage would create adverse effects which would be greater than those caused by traditional media coverage. You should be aware that Rule 3 places certain limitations on expanded media coverage. It also allows you to terminate expanded media coverage. You should familiarize yourself with all of the provisions of the rule. One final point on media-related issues, and it's an important one. Rob McCollum and John Sarche, the judicial branch's public information officers, are wonderful resources. Whenever you get a request for expanded media coverage, you should contact them as soon as possible. Rob and John have a great relationship with the media and have invaluable knowledge and experience in this area. Let me talk next about the order of comments by the lawyers and any other participants in a sentencing hearing. There's no rule here, and there's more than one way to do it. I will talk about how I do it, and Valerie will talk about how she does it. What I like to do is to have defense counsel go first, the prosecution go next, and the defendant go last. I like giving the defendant the last word. I tell the parties that if there are people who wish to address the court, I will hear from them. I leave it to each counsel to decide whether they wish to have such individuals address the court before or after counsel's remarks.
Depending on the number of people who are likely to speak, I tell people that I will hear from the people who are speaking on behalf of the victim, then the people who are speaking on behalf of the defendant, and then I hear arguments from the prosecution and the defense attorney. I also give the defendant the last word.
However you choose to proceed, keep in mind that you want to make sure that you maintain control of the proceedings. I find it helpful to set forth certain ground rules at the beginning of a sentencing hearing. Number 1, all comments must be addressed to me. Therefore, while the victim and the defendant may comment on each other's actions, they may not speak to each other directly. 2, all of the comments must be professional and consistent with the decorum, solemnity, and dignity of the court. 3, everyone must speak up so that my court reporter and I can hear them. 4, it is acceptable to read a document into the record even if the document has been or will be submitted to the court, as long as it is read sufficiently slow to allow for reliable transcription. And 5, an individual is entitled to agree or disagree with what the court and others say in the courtroom, but everyone must act professionally and observe proper decorum. When it is the defendant's turn to speak, I advise him that he has an absolute right to make a statement in allocution. I also advise him that he's not required to make a statement. He doesn't have to say anything. In announcing the sentence, you should always provide the rationale for it. Even if it's a sentence that the parties have agreed to, you should always explain why you believe the agreed upon recommendation is appropriate. It is particularly important to explain the reasons for a sentence when the sentence is in your discretion. First, the parties deserve to know how you arrived at the sentence. Second, the parties will appreciate hearing that you listen to their remarks and consider them, even if you ultimately disagree with them. Third, the record needs to contain your reasons or justifications for the sentence. If the sentence is appealed, there needs to be record support for whatever sentence you imposed. Finally, providing the rationale for the sentence will help you remain mindful of the purposes of sentencing.
In making a sentencing determination, there are some things that you may need. For most felony convictions, a pre-sentence report must be provided unless waived by the parties. Although not a requirement, a pre-sentence report can be ordered for any misdemeanor conviction. The pre-sentence report must include a victim impact statement prepared by the district attorney's office. If a person has been convicted as a sex offender, the pre-sentence report may not be waived and must include an evaluation and risk assessment, unless an evaluation and risk assessment has been completed within the past 2 years and there has been no material change. For some crimes, there must be a sexually violent predator assessment. You also need to determine whether HIV testing must be ordered. If the person has been convicted of a DUI or DWAI, they must also have an alcohol and drug evaluation prior to sentencing, unless it is a first-time offender or if the prior convictions have been stipulated and there is no objection. If the alcohol and drug evaluation is not ordered before sentencing, the defendant must be ordered to complete an alcohol and drug evaluation and follow the education and treatment program recommended in the evaluation. The court may also want a community corrections screen in order to determine the most appropriate sentence. You need to know the sentencing options in your community. Do you have a work release program? Is community corrections an option? Should community corrections be ordered as a condition of probation or as a direct sentence? Make sure you know the mandatory sentences. Also, it's best if you can include and recite the costs and fees that will be imposed, such as the victim's assistance surcharge, the victim's compensation fee, court costs, public defender's fee, genetic testing surcharge, restorative justice surcharge, drug offender surcharge, crimes against children surcharge, any evaluation fees, costs of prosecution, and always consider restitution. There are some cases going around where defendants are seeking to dismiss the sentencing if restitution is not ordered or specifically addressed in some manner. Some conditions may be mandatory, such as a domestic violence evaluation or useful public service. Sometimes you might want to get creative. Some of the things I have done or seen done require significant useful public service, but allow it to be suspended if the person completes education. Require education programs such as Job Corps, but keep in mind that to be eligible, the fines and costs must be less than $500. You might suspend some of the fines and costs if somebody gets into Job Corps, except of course for restitution. Also, for Job Corps, the offender must be less than 25 years old. Also, you could require jail, but have a report date for a year in the future, and if the entire time the person does well, then you can suspend that jail time. You could require a defendant to come to court once a month to check in. Getting creative makes the sentences more specific to the offender. It makes them understand that they're not just a number and can increase the likelihood that they will be successful. And finally, it's very important that you state whether the sentences are imposed concurrently or consecutively. Some are required to be imposed consecutively. Others are at your discretion. Either way, make the record.
After you announce the sentence, you should provide the defendant the advisements set forth in Rule 32C of the Colorado Rules of Criminal Procedure and Section 18.1.3404 of the Colorado Revised Statutes. These are mandatory advisements.
Thank you for your attention.
And remember, don't hesitate to contact us if you have any questions.